Here's what that jury unanimously said. They said that a public nuisance exists because of the collective presence of lead in Rhode Island. That it's not about 5 homes or 93 homes. It's about the fact that this is everywhere. And any particular day, a home that has never produced a poisoned child before, that we've no idea has lead paint in it, can end up, because of someone doing renovation work or even doing something as simple as opening and closing their windows repeatedly, can produce a poisoned child. Second, the jury found that 3 of the defendants, Sherwin-Williams, Millennium Holdings, and NL Industries, are liable for the nuisance. That was after listening to months of evidence about what these companies did and didn't do to create that public nuisance. And finally, that the 3 defendants should be responsible for abating a nuisance. There are so many legal issues that have come out of not only the Rhode Island case, but the other public nuisance cases, many of which are fascinating, but the one I'm going to focus on is what I started with, which is the distinction between the product liability and the public nuisance cases. And there's been significant precedent that's come out of these lead cases that applies not only to the lead cases, but also to other public nuisance cases that could be brought elsewhere. State of Rhode Island. After the jury verdict, there was extensive briefing, 200-plus page briefs that were filed, motions for a new trial, motions to overturn the verdict, motions for a directed verdict, and the judge, it was about a year between the verdict and when he wrote a 197-page decision that addressed a whole host of public nuisance cases. But one of them that's been particularly interesting and has become the source of a lot of discussion is whether there's a requirement for product identification. In other words, do you have to prove that it was Sherwin-Williams paint, or Glidden's paint, or NL's paint that was in a home or particular homes before you can hold them responsible under public nuisance? And of course, product identification is something that is required in most product liability cases. There are a few that have a risk contribution or market share theory, but that's kind of the hallmark of a product liability case. And the manufacturer said, well, look, if you sued us in a product liability case, you had to prove it was our product. You have to do that in public nuisance as well. And the trial court in Rhode Island said, no, you don't have to do that. And he stressed, as he did numerous times, this is not a product liability case. You can't look at it as a product liability case. And nowhere in the law of public nuisance is there a requirement of product identification. It doesn't exist. You can't incorporate those product liability concepts wholesale into public nuisance cases. Santa Clara versus Atlantic Richfield Company. This is one of the cases that Mr. Spellman referred to, and that was a case that the 6th District California Appellate Court, in a lengthy decision, found that public nuisance is an applicable theory in lead pigment cases. The California Supreme Court rejected the petition for cert on this case. And the California decision is a great decision because it very succinctly, in certain sections, deals with what the allegations are and what the legal theories are. And here's what they said about the allegations. So here, Santa Clara, San Francisco, and Oakland, those are the plaintiffs, allege that the defendants assisted in the creation of this nuisance by concealing the dangers of lead, mounting a campaign against regulation of lead, and promoting lead paint for interior use, even though defendants had known for nearly a century that such use of lead paint was hazardous to human beings. Defendants engaged in a massive campaign to promote the use of lead on the interiors and exteriors of private residences and public and private buildings, and for use in furniture and toys. And this is the key on the causation. Had defendants not done so, lead paint would not have been incorporated into the interiors of such a large number of buildings and would not have created the enormous public health hazard that now exists. And what Santa Clara Court recognized, like the Milwaukee Appellate Court, like the Rhode Island Trial Court, is if these defendants hadn't made the choices that they did, be they 50 or 60 or 70 years ago, we would not be in the position that we're in today, where children's lives and health are being compromised. The California court went on to recognize the distinction between product liability cases and public nuisance cases, and really crystallized this issue. And they stressed that a representative public nuisance cause of action seeking abatement of a hazard created by affirmative and knowing promotion of a product for hazardous use is not essentially a product liability action in the guise of nuisance, a nuisance action, and doesn't threaten to permit public nuisance to become a monster that would devour in one gulp the entire law of tort. They said, this isn't the sky is falling, the sky is falling. If you let this go forward, everyone's going to come in public nuisance cases, because they recognize you need a unique plaintiff and you need to have a very unique remedy. And it goes on to say, because this type of nuisance action does not seek damages, but rather abatement, a plaintiff may obtain relief before the hazard causes any physical injury or physical damage to property. A public nuisance cause of action is not premised on a defect in a product or a failure to warn, but on affirmative conduct that assisted in the creation of a hazardous condition. This isn't a crazy theory that has been dreamt up by some wacky lawyers in their offices and then sold to the public. This is a theory that courts across this country are recognizing as a viable way of protecting the public health from a known danger. California court went on and noted the contrast with the product liability action. I'm not going to read through all of this, but it notes that product liability action is brought by an individual injured plaintiff versus the government official. Recognize that a product liability doesn't provide an avenue for protecting the public from future harm. And also the availability of the abatement remedy. And they say, for these reasons, we are convinced that the public nuisance cause of action in the third amended complaint is not a disguised version of plaintiff's product liability causes of action. I think this slide sums up what public nuisance is and what public nuisance is not. We heard a little bit about landlords and blame being cast on landlords. And we heard from Mr. Spellman about parents, and we heard about what the state is or isn't doing. The entire gist of these public nuisance actions isn't to say that the lead pigment companies alone are responsible or bear all of the responsibility for what has happened here. But what it does recognize is that the state and taxpayers, parents and homeowners, have been the ones who've been sitting at the table since 1991. So when you hear about these drops in the number of children who've been lead poisoned and the public health success story, and the fact that Rhode Island is reaching 5% or less poisoned, it's not because of what these defendants have done, it's because of what homeowners and parents and landlords and state and taxpayers have done. And what the jury found in Rhode Island is that this last piece of the pie, the defendants, since they will not come to the table voluntarily to help solve this problem, through public nuisance causes of action, can be held accountable and can be made to share in the responsibility and to become part of the solution to the problem instead of part of the problem itself. Thank you.
Thank you very much, Fidelma. Now we have Mike Nyland from Minneapolis.